Firstly, Vinette, I want to thank the Honourable Arnim Eustace and the NDP. I want to thank him firstly for his courage as a leader to speak on a matter of fundamental concern, not just to the people of St. Kitts and Nevis, but to the wider Caribbean region. Indeed, what is happening in St. Kitts is deplorable. It is an abomination. And the fact that heads of CARICOM has to date not spoken with one voice on this significant matter, which basically is a subversion of democracy taking place in St. Kitts and Nevis, is a real tragedy. And that this tragedy had prolonged so far for nigh 15 months, indicate in large measure to me that the CARICOM heads have lost their good offices, and therefore it is a significant challenge and a significant disappointment. In December of 2012, the Honourable Leader of the Opposition in Parliament, Mark Brantley, served a motion of no confidence on the Clerk of the National Assembly. And in keeping with all traditions of democracy, a motion of no confidence ought to be given priority. Indeed, we saw not too long ago in Barbados how expeditiously such a motion is dealt with. Mayor Muttley, the Honourable Leader of the Opposition there, the Friday of one week indicated at the close of one debate, if I'm recalling, that she was going to present a motion of no confidence. By Tuesday, it was filed, and on the very Tuesday, the government cleared the calendar of Parliament to ensure that the motion of debate could be dealt with expeditiously. And when the Honourable Prime Minister in Barbados was asked about the timeliness, he said, well, the motion of no confidence is a charge against the government, which this government must answer, and it must answer expeditiously. So there is ample precedent within the region as to how urgent a motion of no confidence is, and that it is a critical charge which every government must discharge as often as it raises its head. And indeed, if we take other jurisdictions such as Trinidad and Tobago, Kamla Persad-Bissessar, new Prime Minister has had to deal with some 3 motions of no confidence. We go to a small country like Montserrat, and the Chief Minister and latterly Premier of Montserrat has had to deal with at least 2 during his short tenure, first term as Chief Minister Premier. We go to St. Martin, close to us in St. Kitts and Nevis, just about 15 minutes away. And within 7 days, a motion of no confidence in the government is being disposed of. So the ample evidence throughout the Caribbean, and whether it is Barbados or even Grenada, where Tillman Thomas as Prime Minister faced 2 motions of no confidence, there is clear evidence that the convention, the practice, is that these matters are dealt with expeditiously. In the case of St. Kitts and Nevis, what is happening? The Prime Minister, illegitimate as he is now, having seen and added the membership of the House, understands that there are 6 members of Parliament now who have indicated formally to the Governor General that we are going to support the motion of no confidence. And therefore it is clear, based on the arithmetic, that the Prime Minister in St. Kitts and Nevis, the illegitimate Prime Minister as he is now called, could not survive a motion of no confidence. And in the context of that, we are seeing all kinds of dramatics, all kinds of efforts being made to forestall a debate of the motion in the Parliament, where it ought properly to be debated, to be voted upon by the incumbent regime. Thankfully, on February 12th, last it was, that the High Court judge had an opportunity to outline the status of the law in relation to the motion of no confidence. And he did in fact find, importantly, that we, the members of Parliament, had a substantive and procedural constitutional right to have a motion of no confidence put and debated by the Parliament, and that in large measure the undue delay in the hearing of this motion tantamounts to an infringement of our constitutional right. And he went so far, importantly, to say that we live in a constitutional democracy, as we do in most of CARICOM member states, and that under that system of government, I just read briefly, he said, under this system of government, the term of the Prime Minister and his cabinet is only validated by the support of a majority of the elected members of the Assembly. It is the mandate of the people through the elected representatives that the Prime Minister and his cabinet is given the right of government. By a number of express provisions, the Constitution expressly stipulates that if a majority of the elected representatives vote in favor of a motion of no confidence in the government, a Prime Minister and his government will cease to have the right to govern. The Constitution expressly not only provides that on such a vote, the Prime Minister is to either resign or else Parliament is dissolved, but it also expresses an urgency that should follow such a vote of no confidence. It would therefore make nonsense of these provisions if a majority of members of the elected representative may have lost confidence in the government and being ready and willing to vote on such a motion, have requested that such a motion be placed on the order paper, but no steps are being taken to have such a motion debated and voted on within a reasonable time as a matter of priority. So here the judge is saying we are making a nonsense of the constitutional democracy. And in the constitutional democracy, as we practice it, by and large, whenever a majority of MPs, elected members of Parliament, coalesce, come together and decide to give support to one of their members, it is from that the validation of the office of the Prime Minister and the government flows. In the context of St. Kitts, put another way, we are saying that the government at home continues to operate without appropriate constitutional basis. It is illegitimate, it is illegal in our view. And it is in the context of this reality now, outlined by the judge, that we believe that the heads of government of CARICOM could no longer be silent if they are truly dedicated to the rule of law, to the agenda of good governance outlined in the CARICOM Charter of Civil Society, and the democracy which they talk about so much. They must want to see that live to its fullest expression in St. Kitts and Nevis and the wider region.
Now, when we in St. Vincent have questioned this thing, the Prime Minister is on record as saying that the matter has become tied up in the courts. And so this is why there is no place for a comment on the matter coming from CARICOM. So the argument is that it is sub judice, so you can't talk about it because there'll be some kind of prejudice if you do. Was that addressed in the judgment? I believe that from
Yes.
my scanning it, there was some mention made.
It was in fact addressed, and we are grateful that the judge in fact again elucidated the finding of law in relation to that. I believe that your own Prime Minister is smart enough to know that the sub judice argument was not a valid one. It was a convenient argument put forward by one of his colleagues without any basis, even before the judge had an opportunity to deliberate on this matter. Three eminent Queen Counsels in St. Kitts and Nevis, in Charles Wilkin, in Emil Ferdinand QC, in Tapley Seaton QC, had put their professional reputation on stake, so to speak, come in publicly and say that the legal proceedings before the Parliament were not enough, as it were, to prevent the Speaker from convening the House to deal with the motion of no confidence. Your Prime Minister would have known that. But this is what the court found. The court confronted this head-on in its judgment at paragraph 146. And I quote, "Before leaving this issue, I have noted that the Speaker has stated that he considers that the last reason why the matter was not listed is because he considers that it is sub judice. In this context, he has also referred to Standing Order, Section 43, subsection 1, which provides, reference shall not be made to any matter which is sub judice in such a way as might, in the opinion of the chair, prejudice the interests of the parties hereto or thereto. The court proceedings have arisen because the complainants, that is we in the majority, wish to have this motion of no confidence heard. This is why this matter is in the court. If the matter is now placed on the order paper and debated, the court proceedings may become moot and merely academic. Regardless, however, said the judge, there could hardly ever be any prejudice caused to the interests of the parties in the court proceedings if the assembly were to debate and vote on the motion while it is still pending in the court. So again, the judge dismissed that argument as not one founded in law and the serious principles which ought to be upheld in relation to the sub judice matter before the court. So every argument that the government and those who apologize for the government put forward, they basically were addressed by the court and basically dismissed. At one point they argue, oh, the motion is in bad form. And in the Prime Minister's own letter to Mr. Gonzalez's letter to Arnim Eustace, which I see in the press at one point, he said, well, yes, the motion once is in good form and so on, ought to be put before the Parliament for the debate. The judge said, listen, this is not a matter for the Speaker to inquire into. He has to take the motion for what the motion says. On the face it is. If it says it is a motion of no confidence, treat it as such and let the Parliament decide, because ultimately it is the Parliament that will debate it. And when they vote on it, then you will have the determination as to what in fact it is. So the judge threw out that argument. They raised another foolish argument. Well, you see, those who are opposing now, two of them were ministers of government. How could they support a motion of no confidence? As if we live in a world where we're all ignorant. That we forget that, for example, in Barbados, with Erskine Sandiford, it was a majority of MPs on his own side who had enjoined with others and the opposition because they could take no more of Sandford's approach to government. And that is how motions of no confidence all over the world are. You start with the presumption that the government is intact, that it has support of a majority of elected members. What happens when the government goes awry? That the government begin to do the worst kinds of atrocities? Is it that you have no say, no voice, and that you as a member of parliament committed to ill will towards none, to do what is best for your country, that you continue to serve almost slave-like and slavelishly a government that has lost its moorings? That is what the motion of no confidence is. It provides a check on government, not a check on opposition, a check on government. And the fact that the Constitution went so far as to tell you what is to happen once a motion succeeds tells you largely that this is a matter of great significance. We don't have the impeachment and recall procedures in the form outlined, say, in the USA, but we have a no confidence provision, which is tantamount to giving you the same effect It is the people's power being exercised through their parliamentary representative to recall the government that is being exercised through a motion of no confidence. The truth is, motions of no confidence do not always succeed. As for example, in the case of Tillman, some people who perhaps one had thought would have supported the first motion didn't go, so the motion was defeated. But elsewhere we have had cases, the Cayman Islands, Barbados I mentioned, where motions are put and they succeed, which means there is an overwhelming, or at least a majority view that the government ought to change course in relation to the matter.
I wanted to read because I want to point out, and our listeners, an observation was made by the leader of the opposition in St. Vincent that we have been speaking about this. As a matter of fact, from August last year that you wrote to the Prime Minister and, urging for some sort of intervention on the matter. And, Vincentians are listening, trying to understand, trying to grasp it. And grasp what the entirety of the situation was. Yeah, and it's only last week people started to call and really say, well, listen.
Yes.
What is happening? What is happening? I wanted to read from the Jamaica Observer because the charge was one of hypocrisy on the part of the leader of the opposition. And the Observer basically reproduced the entire statement that was made by the NDP's leader here and said, because where he said, what I find most disheartening is the deafening silence of the other CARICOM governments who appear to wish that the situation in St. Kitts did not exist. Eustace said that regional leaders should hang their heads in shame for condoning this unacceptable state of affairs. And to my mind, that still echoes while we wait to see what will happen on Monday and Tuesday. Because we have had in the press the detailing of what the agenda will talk about, medical marijuana. We had them saying, they're very concerned about the Ukraine. They're concerned about Maduro and what's happening in Venezuela, but nothing on St. Kitts. And I thought it interesting what the chairman of CARICOM, our own Prime Minister, says. He says, there is no hypocrisy there. Where in CARICOM's statement is it hypocritical? Talking about the fact, the hypocrisy is you're talking about what's happening in Venezuela and you're ignoring our own backyard. So he said, because St. Kitts and Nevis has a unicameral system, the government can still get its legislation passed as the senators can vote. So apparently his thinking is that when you disable the senators, then is when you all fall down. I don't know. I don't get that logic. But anyway, he said the opposition had filed a vote of no confidence in the government and went to the courts when they felt it was not being heard. And it get tied up in the court. This is a direct quote from the Prime Minister. And I want you to address that so that Vincentians and those listening in the diaspora and those listening in St. Kitts, because he's speaking here for CARICOM. Our Prime Minister is speaking for CARICOM. And I would love for you, please, to address what he is saying is the reason why CARICOM can't intervene. And I know that they're listening to this program, and I know that it must inform some kind of future conduct being what happens on Monday, Tuesday. Here's what he said to the Jamaica Observer. It get tied up in the court. That's what has happened. I mean, any first-year child in politics should have told them this is a political question. Don't go and tie yourself up in the court because you are using a tactic which the government would love. Gonsalves said that he has written to Prime Minister Douglas, indicated that there is a sense of uneasiness when a motion of no confidence is not heard in a reasonable time, but that in fairness, it is the opposition that went to court. The opposition has locked itself into an internal process. And I want you to respond to that, because to my mind, that is saying the matter is sub judice, so we in court.
Yes. Well, I don't have to tarry long on that, because I said earlier that it was a nonsense argument. It was a nonsense argument because, as I said, persons who are learned in law and aware of what was had already, there can be no greater constitutional lawyers than Charles Wilkin, Emile Ferdinand, and Tapley Seaton in a St. Kitts and Nevis context. And when these people would put their professional position on the line, explicitly say what they said, then we know something was awry. But the Prime Minister here knows, and part of it is a convenience of treating with very serious matter, because how does he then disentangle himself, having admitted that the motion ought to be held expeditiously? Your Prime Minister must be aware that we in the opposition waited for 103 days. And I challenge your Prime Minister to find within CARICOM member state, in fact, find with any Commonwealth country practicing democracy, that you have had a motion of no confidence held in abeyance for 103 days. It is after that unprecedented delay that the opposition determined that the only way we are going to get ahead is to go to court on the matter. Because where else do you go when there is a dispute among people other than to the court in a practicing civil society predicated on the rule of law, which they want us to abide with? So we went to the court to have an adjudication of our rights. If the government had acted even within 1 month, because we waited from December 11th until April 3rd, some 103 days before we took the matter before the court. In all that 103 days, was there a letter going to the illegitimate Prime Minister in St. Kitts and saying you're setting a bad precedent? Because 103 days by themselves is an astounding delay in relation to the urgency determined by the judge and determined by practice within CARICOM member states. In Grenada, in less than a month, the motion was dealt with. In Mount Strat, within days. Kamla Prasad, within 14 days, each motion put have been dealt with. And when our leaders look to the least common denominator to set standards, it becomes dangerous for the quality of life. When they can compromise thinking and find excuses, subterfuge, rather than deal with the substance of issues, we begin to tread on dangerous grounds. So we waited 103 days before we went to court. And when we went to court, they said, well, you put it before the court, so it's now sub judice. Out of an abundance of caution, we went back and we said, let us withdraw the matter. Since the Prime Minister of Gonzales said it's sub judice, sorry, of St. Vincent, and others, and that excuse were there, because we only went to the court to have the matter been heard. That is our contention.
Right.
So on one hand, you are saying that the man is not bringing the motion, and you must do nothing, stay quiet, don't seek no relief from nobody. And at the time, your constitutional right as a member of parliament is being infringed. Where do you go? Is it that they want to see riot and carnage in Bastille to bring home the fundamental violation in the democratic order, which they know as leaders is taking place? They are losing their conscience as leaders. But importantly, when we went to the court to say, withdraw the matter, The very government which had given an explanation repeated by your Prime Minister that the matter is sub judice, and because of that we ain't going to do anything, can't do anything, our hands become tied. We go back to the court to withdraw the matter, discontinue it, to untie their hand, and then the government said, no, don't take it out of the court.
What?
They went to the court to appeal against that.
So
to
hold
ask
on.
the court to continue the very matter in court, which they said was tying their hand. It became very clear it was a political game of brinksmanship, that the government had no interest in hearing the motion, because the reality which it faced was that it could not survive a motion of no confidence. The court then became part of a delaying tactic that had been used. And what ought to have happened was for the leaders in the CARICOM to sit through that, to pierce the veil of deception of Dr. Douglas at home and call a spade and say, Dr. Douglas, you can't eat your cake and have it too. You can't say the matter is before the court, so you can't do anything. And when they go to the court to discontinue the matter, you then take an application before the very court
to leave it there.
And say, leave it there. We want the matter tied up in the court. What are they saying to us? How are they treating us? They need to treat us as informed people within the Caribbean, and they need to give us leadership of truth again in relation to these matters that are fundamental. So that is why the matter went to court, because the government was not doing what it ought to do. It wasn't doing the right thing.
Well, let me ask both of you. How
the end point on that is that with all this talk from whomsoever will within CARICOM, the court has now found that the matter is not sub judice, and that hearing the motion does not prejudice anybody's right. In fact, the court in its judgment in February 12 said, listen, we would basically prefer that this matter doesn't have to come back to us again, because the law is so clear in relation to this matter. Just do the right thing. And that is all we are asking as an opposition in St. Kitts and Nevis. The government that has lost the constitutional basis ought not to continue to function. And CARICOM leaders, by and large, ought not to be encouraging the presence.
This is my question. I was asking both
Prime
of
Minister
you.
among them.
I was asking
in the context of this reality.
So this is my question to you. The illegitimate Prime Minister, as you describe him, arrives to come to a CARICOM heads of government meeting. How should CARICOM leaders react? You put yourselves in their position, and what happens over these next 2 days to address this St. Kitts matter?
They don't have it on the agenda.
No, but let's say, okay, they're not saying they have it on the agenda, but after compelling, the situation to my mind is so compelling, it cannot be ignored as far as I am concerned.
Well, I agree, it ought not to be ignored.
Right.
But we have men of the legal men, like our Prime Minister, making all sorts of statements which he knows are not true.
Right.
They're constitutionally wrong.
So
they're not in accordance with parliamentary rules and practices.
So you're saying that every single leader in CARICOM is going to follow the lead of someone who is not reading and not understanding the position in law, and they're going to follow the lead and do nothing for the next 2 days of meetings?
But let's not put them and wait and see.
Let's
what
see.
we now know, they have a court judgment that has taken away all of the excuses that have been put forward before.
Okay.
The sub judice point, for example, can no longer be harnessed again in the context of a judge findings.